Good evening, everybody, and thank you for joining the Junior Labour Lawyers for our event tonight that's looking at the question of will Brexit lead to a codified constitution? We're very lucky to be joined by three leading experts in this field who are doing highly relevant work to this question. So we're first joined by Professor Meg Russell. Meg Russell is a professor of British and Comparative Politics and director of the Constitution Unit at UCL. Before joining UCL, Meg was a consultant to the Royal Commission on Reform of the House of Lords, and from 2001 to 2003 was seconded as a full-time advisor to Robin Cook in his role as leader of the House of Commons. Meg's current areas of work involve Brexit, Parliament and the Constitution, as well as the role of citizens' assemblies. We're also joined by Professor Sionaidh Douglas-Scott. Sionaidh Douglas-Scott is a professor at Queen Mary, University of London, and also my old university, so not playing favourites or anything here, University of London, and is the Anniversary Chair in Law. Previously, Sionaidh was Professor of European and Human Rights Law at the University of Oxford. Sionaidh is also a member of the Advisory Board for the Constitution Society, as well as for the International Society of Constitutional Law. Sionaidh also has also been awarded a Leverhulme Research Fellowship to work on a project to do with Brexit and the Constitution and the British constitutional settlement following Brexit. So that's obviously highly relevant to tonight's discussion. And we're also, as I say, joined by Dr. Andrew Blick, alongside his role as a reader in politics and contemporary history and director of the Centre for British Politics and Government. Dr. Blick is Director of History and Policy, a UK-wide initiative led by King's College London and the University of Cambridge that brings together historians and policymakers. Dr. Blick was advisor to the Welsh Government in its intervention in the landmark Supreme Court Article 50 case of 2016, and from 2010 to 2015 he was also a research fellow to the first ever inquiry into the possibility of introducing a written constitution for the UK, carried out by the House of Commons Political and Constitutional Reform Committee. I think we'll kick off if we go for Professor Meg Russell first, please.
Okay, thank you very much. Thank you for inviting me to this event, and I look forward to hearing what the other speakers have to say and to the discussion afterwards. So the question we've been set is whether Brexit will lead to a codified constitution, and I think it's important to distinguish between two different questions here. One is, should it lead to a codified constitution? And the other one is, will it? These are clearly different but related questions. So I'll start with the should it and then move to the will it, and then end by asking what we maybe should be focusing upon. So many people have argued that Brexit should lead to a codified constitution, including some of those who've been arguing for such a thing for a long time. One of the notable proponents of this is Vernon Bogdanor, whose book, Beyond Brexit Towards a British Constitution, argued that when we were in the EU, we were to some extent constrained by a kind of codified constitution, and that by coming out of the EU, our constitution has become what he refers to as unprotected. Therefore, the need for codification is greater than before. He's particularly concerned about untrammeled parliamentary sovereignty, leading to an unchecked executive. In addition, he points out, and this is fairly obvious, that Brexit has thrown up some very difficult constitutional questions about the role of referendums, for example, the balance between the centre and the devolved institutions, and between government, parliament and the courts. So altogether, he argues that Brexit is what he calls a constitutional moment, which I think at one time was going to be the title for this event, is Brexit a constitutional moment? I'll come back to that idea. It's certainly unarguable, I guess, that Brexit has shaken things up constitutionally in all the ways that Bogdanor has pointed to. It could be said in some respects that that's a result of us not having had a codified constitution in the first place, the flexibility of the constitution having got us into this situation. So, of course, when I say codified constitution, I'm referring to something, the key thing being a legally entrenched constitution in the shape of one single document. Perhaps if we'd had one of those, we wouldn't be where we are now. I think depending on what the Constitution said, there are clearly ways in which this could be the case. So with respect to referendums, first of all, that's something Bogdana focuses on a lot, and we've focused on at the Constitution Unit a lot in our work. We hosted something called the Independent Commission on Referendums, which reviewed the use of referendums in the UK post the Brexit one and reported in 2018. It's one of the features of the use of referendums in the UK Constitution is that there is no specification for when they should be used and what for. The history of referendum use in the UK, which has gradually grown, has been that they have always in practice been used on constitutional questions. But of course, what a constitutional question is ill-defined in the British system, and there is no constraint on what they can be used for and when. In other systems that have codified constitutions, at least when you have a constitution on a referendum on constitutional change, it would be clear what the meaning of a vote for change would be, because you would in effect be voting on a constitutional amendment. And one of the things which the Independent Commission on Referendums was very critical of was the fact that referendums get held without the meaning of the outcome being spelt out. And that was very, very clear on Brexit. But also when you compare with other countries, one of the things that we do uniquely is hold referendums on things as a sort of single stage process. Referendums on constitutional change in other countries with codified constitutions generally set out a multi-stage process. The whole point of constitutions being harder to change than ordinary law, and Parliament is part of that process. So you would typically see a vote in Parliament on a change and a referendum on the same change, and a sort of double lock in that regard. In the UK, we have sometimes used referendums in that kind of way. If you think of the devolution referendums in the 1990s, for example, it was clear that Parliament was in favour of devolution, and there was a sort of, the referendums themselves served as a kind of consultation mechanism and cementing the commitment to that change. So referendums are not always problematic in this regard, but if you look at the Brexit process, one of the most striking things, I'm a scholar of Parliament, is that there never was a formal debate and a formal vote on whether we should or shouldn't remain in the EU, which is pretty surprising given the size of that decision. There was a vote to hold a referendum, and I guess one of the key reasons why the referendum was held in that way without there having been a vote in Parliament was a level of complacency about what people expected the outcome to be. They hadn't really adequately taken the prospect of a leave vote seriously. Other aspects of, if we had a written constitution, if we had a codified federal constitution, things might have been different, in as much as we might have required a different kind of double lock or more through agreement in different parts of the UK to leave the EU. And even if not that, then subsequent to that decision, there would have been more of a double lock on the nature of Brexit that was negotiated. And none of that happened, and that's been quite divisive. If we had a codified constitution, then perhaps the Prime Minister wouldn't have been able to prorogue Parliament for 5 weeks at one of the key points in the Brexit process. Perhaps there wouldn't have been so much negativity towards the courts during the process, because people would have been more used to them being involved in these kinds of questions. But all of this depends on what the codified constitution itself would have said. And none of these things, the protection of referendums, the protection of the devolved institutions, etc., or the prevention of prorogation would be guaranteed simply by the fact that the constitution was codified. And of course, there are famous classic benefits in having a flexible political constitution. Indeed, if the constitution had been more rigid, then there are questions about whether some of the other previous changes, not just Brexit, but the other previous changes to our constitution would have happened, perhaps even including devolution itself. Change would have been more difficult to achieve. Of course, that's a debatable point, whether that would have been a good thing or a bad thing, but it's worth bearing in mind in this discussion. One thing I think that's very clear is that a codified constitution would not act as a bulwark against populism. Brexit was seen by many as a populist moment, a kind of kickback against the elites, and subsequently populist rhetoric has been on the rise, with being directed at Parliament, the courts, and other institutions. But sadly, this can be seen very clearly as part of a global trend. We're seeing these kinds of moves in many countries around the world, most of which have codified constitutions. In fact, Jonathan Sumption argues, and I think this is one of his more convincing points, that political trust may be eroded if difficult political decisions are dealt with through the courts rather than through more deliberative and democratically accountable forums. I don't deny for a minute that we're at a dangerous moment. I'm very worried about the erosion of constitutional norms. We need to take this very seriously. But the same challenges are currently being faced all over the world, codified constitution or not. Turning to the other question of whether it will happen, more briefly, even if the lack of a codified constitution helped us to get where we are, that's clearly a very different thing to saying that Brexit is going to lead to one. Indeed, in some ways, I think Brexit makes it harder than ever to get there, at least at the moment. This has been a period of pretty unprecedented disagreement about all manner of constitutional rules, including some of those that I've just referred to. We've got well-established habits of debate on possible constitutional changes, for example, to the electoral system, options for devolution in England, and the various options for the House of Lords. The traditional flexibility of our constitution, I would argue, makes these debates more likely than they are in most other states. We're kind of in an ongoing debate on possible constitutional change, given how relatively easy that is. But all of those debates are still going on at the same time as things which might previously have been seen as settled being brought into question. So those words from page 48 of the Conservative Party manifesto, the relationship between the government, parliament, and the courts, and indeed you could bring in the monarchy there as well, are now under question. This, to me, makes it less likely than ever that we're going to be able to agree a document setting down in relatively rigid terms how these institutional relationships should work. Indeed, Lords reform is one of my specialist subjects, and even agreeing a simple statute on that one thing, how we should reform the House of Lords, has proved too politically difficult to achieve for more than 20 years. So perhaps this leads us to Vernon Bogdanar's suggestion that there's something unprecedented about this moment, that actually we're going to unlock constitutional change because Brexit has created a constitutional moment. Bogdanar doesn't really define the term constitutional moment, but it is frequently used, and it generally means those moments where some form of crisis gets you to the point of sitting down and rewriting your constitutional arrangements. Classically, that would be, for example, following revolution or defeat in war or occupation, that kind of thing. So in the classic sense, thankfully, we're not at such a moment. Brexit strained our constitutional arrangements close to breaking point, but thankfully it didn't actually lead to system collapse. In that sense, we should be pleased if we have avoided a constitutional moment in that sense. But of course, it is possible that we could yet reach one. Brexit may help to lead to Scottish independence. It could also perhaps lead to Irish reunification. If it did, we would be close to one of those moments where we require a blank piece of paper and sitting down and working out how we want our system to work. But those really wouldn't be happy circumstances. Whatever your views on the desirability of those two things I've just mentioned, the process would be very, very messy and it could get very unpleasant. So I personally hope that's not where we're going. Could we sit down more constructively and try and agree a constitution? That's something the other speakers may comment on, and I'm happy to talk about that. But I personally think it would be very difficult in such turbulent times. And in fact, some flexibility may be exactly what we need at this moment. In general, just ending on what we should focus on, I always think that more important than constitutional structures is constitutional and political culture. My main concern is about a breakdown of trust and a culture of anti-politics, which has been growing for a long time and has been very visible over Brexit. It's naive to think that could be sorted out by certain institutional fixes. The current democratic malaise is common to countries with written constitutions and not, with different electoral systems, federal and unitary, bicameral and unicameral, monarchies and republics. So fixating on particular institutional changes risks being a displacement activity, diverting political energy away from the more challenging common problems of how to make democracy and politics work in the contemporary world. I don't think judges can rescue us from a culture of anti-politics or a disillusionment with democracy, though they undoubtedly have essential roles to play in the political system. The really urgent task, I think, is rebuilding faith in political decision-making and in the essential role of checks and balances in underpinning democracy. We increasingly live in a culture which is intolerant of those things, and that, I agree, should really worry us. Thanks very much.
Thank you very much, Meg. I shall move across to Sionaidh now.
Hello, well, thank you very much for the invitation to speak this evening. My little talk is also going to be divided roughly into two parts. The first part is going to be why we are in what could be called a constitutional moment now that could require changes to the constitution. And secondly, if I have time to get onto it, what might be done about it. But I think it's really worth stressing why there are various factors at play that are putting the UK constitution in almost crisis point. The first is devolution, which is the most pressing. Secondly, there is just all of the constitutional changes made by Brexit. And thirdly, there's the issue of fundamental rights and the removal, as Vernon Bogdanor has said, of their formal protection under EU law. And really, all of these three really come down to the changes and effects of Brexit. So starting with devolution, which Boris Johnson rather unhelpfully described as a disaster, start with Scotland. I mean, we're a month away or so from the prospect of either a second Scottish independence referendum or a standoff between Holyrood and London. And a lot of this is a direct result of Brexit. Scots were divided in 2016 in the referendum, 2-1 to remain. Northern Ireland also voted to remain, yet their votes were treated as of no constitutional consequence. And Scotland was forced to leave the EU along with the rest of the UK. A unified approach was taken. And that reopened the independence debate, which had never really gone away, but it certainly it accelerated it from 2014. Many Scots now feel the only way to rejoin the EU is to break away from the UK. And more than ever, I think nationalist and European causes in Scotland have come together and they're gaining support. 2020, first time polls gave repeated majorities for Scots favouring independence. So the crunch will come with the May elections at Holyrood, where the SNP looks set for a majority or majority with the Greens. And the question then whether that could lead to a fresh referendum on independence. And with the Conservatives in power in Westminster, the SNP in Edinburgh, the stage is set for a constitutional crisis, the risk of the breakup of the UK or something else. Northern Ireland, we're beginning to see a resurgence of the worst violence for over a decade from the Protestant community feeling betrayed by Brexit. So not only do we have frayed relations between Britain and Europe, but also dangerous political developments in Ireland. And for all Brexiteers' boasts of restoring British sovereignty, the Northern Ireland Protocol does erect barriers between one part of the UK and another. And so this, arguably, infringes the Good Friday Agreement because it's a change to the constitutional situation in Northern Ireland without the consent of all members of Northern Ireland. Loyalist paramilitary groups have already warned Johnson they're withdrawing their support for the Good Friday Agreement. But of course, there's also the prospect of a referendum on Irish unification looming in the sometime future. So the situation in Northern Ireland is not stable either. So I think devolution is really a very, very big problem, and what could be a bigger constitutional crisis than the potential breakup of the UK. But turning to Brexit in a more definite way, this has been a huge change to the UK constitution, and I'll just detail very briefly a number of ways. Firstly, it's changed one of the UK's fundamental constitutional principles, parliamentary sovereignty. Under the European Communities Act, an Act of Parliament could be set aside if it conflicted with EU law. It meant that parliamentary sovereignty was not as absolute as sometimes presented. Since Brexit, that act has been repealed. But the question is, in that effort to take back control, could you really change the constitution, or has it been rendered different by membership of the EU for those 40 plus years? Secondly, the nature of EU law has changed vastly because its sources have changed. A large part of UK law was sourced in EU law, and now we have retained EU law under the Withdrawal Act 2018. But that act gives huge powers to ministers to repeal or amend those particular sources of law, and it strengthens executive sovereignty, perhaps in a way never seen before. It's also led to a threat to devolved governments. For example, the internal market regulation was once dealt with at EU level. Now it's returned to the UK, dealt with at the UK level, even if devolved powers are involved. So the Internal Market Act has been very, very controversial. Thirdly, the whole act of Brexit reduces the role of fundamental rights. I'll come on to that separately. Fourthly, it raises the question of the role of referendums in the UK law, question of parliamentary sovereignty versus popular sovereignty. I'm not going to say any more about that because Meg's already dealt with that very, very thoroughly. Fifthly, I think the whole Brexit process illustrated the end of what Peter Hennessy and Andrew Blick in a joint paper described as the end of the good chaps theory of government. The UK doesn't have a codified constitution, so it's always relied very heavily on constitutional conventions and on those working within the system, operating with self-restraint. The whole Brexit process illustrated how that self-restraint had vanished and trust in politicians and officials too has been lost. So the political constitution isn't operating as effectively as it used to, and the role of conventions is under strain. The Sewell Convention, which requires that there be legislative consent when Westminster adopts a measure concerning devolved matters, that seems no longer to be functioning. So the UK constitution is perhaps subject to manipulation by those who are definitely not good chaps. Thirdly, human rights. And I'm not going to say too much about this, Meg covered it a bit, but I do subscribe to the Vernon Bogdanor thesis, which is that we have lost a certain amount of entrenchment for human rights with the loss of the Charter of Fundamental Rights, not being carried over into national law. And so any rights, as a result in the UK, any rights legislation is repealable by a bare majority of only one in Parliament. Only entrenchment could provide a guarantee for human rights. Most constitutions protect human rights. And I think we need that protection, especially in Britain's first past the post system, where the legislature can prejudice minority groups, especially those lacking electoral rights. And we've seen how the rights of EU citizens or the Windrush generation have been under threat from parliamentary majorities. In fact, they don't even represent a majority of the electorate, simply a majority in Parliament. In those circumstances, judicial review, currently under investigation in an ongoing inquiry, can be a positive feature, imposing a check on an overreaching government. But there needn't be judicial review by judges for rights to be effective. If you don't like judges, then you could simply have a different system, for example, requiring a supermajority in Parliament to repeal human rights legislation. But with the Charter gone, that form of entrenchment that existed before has now gone. So fundamental rights, to the extent that they existed under the Charter, are under threat, and to the extent that they exist under the Human Rights Act, are also under threat, because Conservative Party manifestos have suggested that when Brexit was done, they would look to the Human Rights Act to replace it with something else. So those, I think, are the three main areas that suggest that Britain's constitution is really in a very serious moment. One could add the coronavirus crisis. I'm not really going to talk about this because I don't know enough about it, but it seems to me there are at least two areas for investigation there. One is the huge inroads that are being made into individual rights in various ways by coronavirus legislation, and that may all be well and good, but the question is the scope of review of the measures being taken, and the concomitant point to be made for implications between the boundaries between the state and the individual. And the other is the relationship between the devolveds and the central government, because coronavirus has highlighted how devolved governments, because this is a devolved matter, have had a very large role to play. And how is that going to work in the future? Because devolved governments and Westminster haven't always worked so well together in the coronavirus issue. I would sum up all of this by saying that actually what Brexit reveals is something that should have been obvious for quite a long while, which is that there are different interpretations of the UK Union and Constitution. And these have really been thrown into the headlights by Brexit. One interpretation understands the UK Constitution as a unified, homogenous nation-state constitution without critical territorial differences, whose constitutional foundation is the doctrine of absolute sovereignty and supremacy of Parliament. It relies on Dicey's view of parliamentary sovereignty, which really, I would say, is nothing more than an assertion. We can argue about this, but Dicey offers very little explanation, either logical or historical, for this doctrine. As Michael Keating has said, it's an empty doctrine. It rests ultimately on a tautology. Parliament sovereignty, because by virtue of its sovereignty. And yet Dicey's understanding has long plagued any ideas of federalising the UK, adopting a written constitution, or settling the UK's relationship with Europe. And indeed, I'd say it's this particular understanding of parliamentary sovereignty that was the real core of the UK's difficult relationship with the EU. And Brexit is premised on the most radical interpretation of parliamentary sovereignty, in which membership of the EU is seen as incompatible with fundamental principles of the Constitution. So we are down to a robust unionism. Now, that's one way of viewing the Constitution. An alternative approach has been to identify other traditions and interpretations as key to an understanding of the British Constitution, viewing the UK as a union state rather than a unitary state. And this alternative interpretation views the UK Union as founded on treaties, the Treaty of Union, 1706, relying on ongoing consent, but it also recognises that the UK has been transformed by external developments and memberships, for example, of the EU in the past and continued Council of Europe membership. It also recognises that the UK has been recalibrated internally by devolution arrangements since 1998, also by the Human Rights Act, and a desire for a more principled constitutional development than parliamentary sovereignty allows. The Scotland Act 2016 declared the permanence of the Scottish Parliament. Now that's a provision which, if it's to have any meaning, flies in the face of orthodox constitutional law's assertion of parliamentary sovereignty. In Northern Ireland, we have seen the development of a concept of a decentralised, fragmented state at work. The Good Friday Belfast Agreement setting out complex provisions regarding cross-community consent, self-determination, and also a role for the Republic of Ireland. So this alternative interpretation looks to more modern understandings of sovereignty, in which sovereignty isn't a fixed characteristic of any given institution, but rather a set of relationships. But after Brexit, we've seen this forced, robust unionism, hyper-unionism, I think it's been called, which is really setting the scene for a tension in the British Constitution. Now, I'm well aware that I've got through my time, but I would say that presently there doesn't seem to be much scope for compromise on a written constitution for the UK, because it's a setting off of these two different understandings of the UK Union and the UK Constitution. I do think there are certain things that could be done that would improve the situation. For example, the House of Lords could be reconstituted as a federal chamber, although, as Meg has said, we see that House of Lords reform is notoriously difficult. But this is a very, very tense, difficult moment. And I don't think we should underestimate the difficulty and the changes, I think, to the UK Constitution wrought by Brexit. I'm going to stop there. I'd be happy to expand a bit further on what changes I think could be possible, but I think a whole-scale written codified constitution for the UK right now under the present government, and not just the present UK government, but also nationalism in Scotland, which is looking to the alternative for independence, doesn't set a very comfortable scene for compromise. Thank you.
Thank you very much. And before we go on to Andrew, I've been reminded very usefully that if you do have any questions, please do pop them in the Q&A box and we'll get to them at the end. So I'll hand over to Andrew.
Thank you very much. Thanks for having me. The two previous speakers have covered a lot of ground very well, so I'm going to try and pick up on some things they've said, but also see if there are areas in which I can add. I think it's, when we think about the idea of a codified constitution, it's useful to define terms when we start. Some of that was touched on, but I think it's useful to expand a bit on some of this. One thing to say is that obviously we often use the term codified. People sometimes use the term written. I know there's a bit of debate about whether we should say written because it implies that our existing constitution isn't written, when in fact a lot of it is written, as we know, in acts and things like that. Although you could also argue that quite a lot of our existing constitution is also codified already in documents like the Cabinet Manual, the Ministerial Code. So there's a lot of semantics going on there, but for argument's sake, I'll use the term codified if that's the title we're using. But what do we mean by a codified constitution? I think the important point to focus on here is the idea that it means we are saying, and it's what we can't really say at the moment, particularly if we accept the dicey view, which I agree is open, is debatable. But what you're saying with a codified constitution is some rules are of fundamental importance, and they are more important than other rules. I think that's the most important thing. It's not so much what's in it, it's that you're expressing the principle that we have some rules that are more important than others, whether it's the rules on how frequently elections take place, or the rules on the powers of respective institutions, the relationship between, say, the House of Commons and House of Lords. These are, and human rights as well. You're saying these rules are fundamental, and they take precedence over other rules. So, and that gets back to the kind of classic dicey argument where he basically says if I think it's a dentistry act or something should inadvertently interfere with the Act of Union, then the Act of Union has to give way because the Dentistry Act is more recent. So that's his kind of statement, really, that you can't have a fundamental rule in that way under our system. Now, I don't fully buy all of that, but I think when we talk about codified constitution, that's what we mean. It's useful to bear that in mind because we can get distracted into an idea of this really, really long document that covers every single possible aspect of our constitution you can ever think of. And then once you think about it like that, of course, we're never going to get there. Of course, we're never going to get consensus all around that. And also the other danger being that a written constitution or codified constitution becomes a kind of shopping list. So it becomes a way by which people can achieve a long series of reforms that they want. They say, oh, hang on, and I think the Liberal Democrats have been a bit, I mean, I'm not trying to play to the gallery here, but I think a tendency, the Liberal Democrats have often supported a written constitution. But when you look at it, what a written constitution often seems to mean is a long list of the changes they would like, many of which would serve to benefit the Liberal Democrats, and many of which I happen to agree with, that's another point. But a long list of things they'd like to happen, and let's just tie it up in a big bow and call it a codified constitution. I think that's a bit of a distraction. I think what we're really talking about is what are the most fundamental rules, and then how do we express that fundamental nature of those rules? What do we do? And one thing is through amendment procedures, supermajorities, referendums, whatever, to make it harder just to change them. And the other thing is giving courts a special role in upholding them. And I think that the courts would have to be in there somewhere, probably to the point that they can, as they were able to do under the European Communities Act 1972, that they can actually disapply or strike down, or whatever you want to say, of an act of parliament if it disagrees with the fundamental codified constitution. I think it's useful to just define terms like that. I'd now like to move on a bit to talk about what does Brexit really reveal to us about any of this. What does Brexit change? As Meg said, it's an interesting debate to be had about whether a codified or constitution would have allowed Brexit to happen at all. And again, that rather depends on what is in the constitution. So it gets back slightly to the shopping list point. But had you had some kind of more defined role for the devolveds in determining constitutions, decisions of major constitutional significance, were they, for instance, included in a federal chamber of a parliament or whatever, then maybe none of it would have happened in the first place. So there's an argument to be had there, and it's an interesting discussion. So I think that Brexit does enable us to think about the constitution a bit differently, what difference it might make. Obviously, it's all too late for those who would have hoped that something like that could have stopped Brexit from happening, but it does make that that kind of debate possible. And I think that's a useful discussion to be had. I think what it also reveals to us is there used to be, and some would still do it, a commonly held position that the UK constitution doesn't do hugely disruptive episodes. We're a very stable constitution. We don't go through immense periods of change or abrupt changes. And that's one of the reasons we haven't got a written constitution, and one of the reasons we don't need a codified constitution, and one of the reasons we don't need a codified constitution, because we're different to other people, and often the implication being we're better. We do gradual change. We change where necessary, but we don't do anything disruptive. It doesn't happen here. Again, I think that's all doesn't really stand up to consideration in the historical record. Let's take one example, Ireland. If you look at the role of Ireland, the island of Ireland, and its relationship with what we now call the United Kingdom of Great Britain and Northern Ireland, that shows an immense amount of disruption, immense amount of disconsensus about what state people want to be part of, and what is the actual extent of that state, and the kind of rules that state's governed by. And obviously takes up to the present day, where we've got, getting our sovereignty back appears to mean in reality applying the rules of the European Union to a barrier within the territory itself, which is a very unusual take on sovereignty. So I think that argument's never really stood up. But in as far as people did believe that the UK didn't do abrupt, disruptive constitutional change, I think the experience of the last 5 years should hopefully blow that argument out of the water. I don't know if it will. It will keep coming back again, but I think that we should reflect on this debate about the codified constitution from that point of view. So I think in some ways it points towards the idea that the codified constitution could in theory be introduced to the UK, or certainly the arguments that have been used against it have either been used to say it can't happen or it shouldn't happen. And as Meg rightly said, those are two distinct, whether it should and whether it can, are two distinct but also overlapping arguments. Doesn't mean to say that the argument's necessarily been strengthened for a codified constitution in the UK. I've argued in favour of one. I still support one in principle, but I don't think that Brexit has necessarily made it more likely or made it more desirable to introduce it at this moment. One thing I would stress is when we think about a codified constitution, let's not claim that it's an answer to all our problems. I think every once in a while, when people think things are going wrong, they say, well, let's get in a codified constitution. That's going to sort everything out. I don't think that's really true. I remember people saying that around the time of the MPs' expenses scandal, which now all seems a fairly low-level kind of event when you look at it. And also, I never quite understood why the MPs' expenses scandal meant we should get a written constitution. And I still don't understand that, but people were making that claim at the time. And again, I speak as someone who has openly supported a codified constitution. I just think we've got to be careful about A, the way we define it, as I've said earlier, and B, what we expect out of it. But there are good things that I think could come of it. And as I've suggested, the most important value to come out of it is we separate out what are the most fundamental rules that we can agree over, and how do we go about protecting them from casual alteration or manipulation from above, as we've seen. And to give an example of something that, for discussion purposes, I think might not necessarily be dealt with at all in a codified constitution, but could be a useful thing to address, is our electoral system. I think if we look at a lot of the disruption we've had over the last few years, a lot of the problems we've had, I think, and I won't go into full detail, but happy to discuss further, I think the electoral system's lying there behind a lot of them. And when we talk about populism, as again, I agree with Meg, what Meg said about populism, been an issue around the world, been an issue in the so-called mature democracies that are supposed to be immune to this kind of thing. If you look at the I can think of two places where the populists have actually come to power, or let me qualify that. I think the current government we've got in the UK isn't an out-and-out populist government. I don't think, and I don't agree with hurling the term populism around as a term of abuse, more of a descriptive term, but I think certainly there's a populist flavour to some of the way it operates. They've come to power. And then obviously the other place that populism came to power was in the US during the Trump. And I think that's closer to saying that's out and out populism. In both cases, the electoral systems in use have got similarities. And in other countries where there is populism, but it seems to be harder for the populists so far, I wouldn't like to make any cast iron predictions for the future, haven't come to power. An example being the Netherlands. It's very hard, it seems, for anyone to form a government in the Netherlands, let alone under the electoral system they've got, let alone an out-and-out populist government. And in France, again, I wouldn't like to necessarily use these countries as models better than us at everything or say we're dreadful, but in France they've got an electoral system that so far has been effective at being loaded against the kind of populist candidate in a presidential election if they make it to the runoff. So that's just an example of something which actually a codified constitution wouldn't necessarily deal with at all, because constitutions don't necessarily have to deal with the electoral system, and I think would need looking at. I would advocate looking at closely as a way of dealing with some of the challenges we face. So I'm trying to show that there are other issues that might require attention, but nonetheless, I think this is an issue which is going to carry on affecting debate in the UK, and is a long-term issue would need looking at. And I'm going to close by talking about what that might mean going forward, particularly from a Labour Party. I speak as a Labour Party member, as it happens, and also, bearing my audience in mind, why might this be significant to Labour? In the lead up to the 1975 European referendum, Harold Wilson, it's now famously remarked that if there were a vote to leave the then European communities, it would leave the wrong people in charge. Well, that was prescient, because I think, not 2016 EU referendum has ultimately left the wrong people in charge. And I think there are people of constitutional malign intent in positions of power. One of them was got rid of late last year, or effectively got rid of himself by his behaviour. I don't think I need to name him, but he's now gone. He was certainly of malign constitutional intent, but I think some of the problems that are associated with his viewpoints haven't wholly gone. We see them in the 2019 Conservative Party manifesto, the attitude towards the judiciary in particular, but also, as was mentioned, the general decline of what we call the good chaps principle. I think the good chaps principle was always overrated as a way of managing a constitution, but there was some substance to it. But in as far as it did exist, I don't think it works as well now. And a really good illustration of it not working is the prorogation episode, that one of the kind of safeguards in our constitution, again, whether you like it or not, this was the safeguard, is that senior politicians do what they can to avoid bringing the powers of the monarchy into disrepute. Well, that was completely ignored. The powers of the monarchy were very clearly used in a way that was calculated in advance to create immense controversy, and certainly succeeded in doing that. And the courts had to intervene, in my view, to sort out the problem that had been deliberately created. And then the courts were attacked in a premeditated way for doing that. So that's an example of the good chaps principle going badly wrong. There are others, but I think that's one of the best illustrations you can get. And this is coming from a conservative party that supposedly conserves traditional constitutional values. So I think we've got the wrong people in charge. I don't mean the Conservative Party, although personally I wouldn't vote for them, but I mean the particular people, some of which actually don't have any real interest in the Conservative Party except as a vehicle for their own agenda. They're in charge, and Brexit isn't the end of the process for that particular outlook. It's the beginning, and we can expect more pressures on the constitution to come, on devolution certainly, on the role of the judiciary. That agenda's received a bit of a setback because the review of administrative law didn't deliver the attack on the judiciary that was hoped of it. Hence, it's been put out to consultation again in the hope that somehow some kind of momentum will be drummed up around that particular agenda. We'll see if that comes off or not. But that's certainly, we can expect more to come. We can expect potentially there's a review of the Human Rights Act going on, this British Bill of Rights, which is always or nearly always actually an agenda for reducing rights, not for strengthening them, or not for making them more British, whatever that is. I don't know why human rights don't apply in the UK. We have to have British rights, but those kind of things on the agenda. So I think sadly, over coming years, I think we're going to see more premeditated culture war type attacks on constitutional principles. And that's why I think the Labour Party will need to get increasingly assertive around these issues, even though some of them may not be seen to play to the mythical voters in Northern England who supposedly need to be appeased to come back on board if Labour are ever going to win an election again. So, that's going to be I appreciate these are all big challenges for Labour. These are not politically easy things to deal with, but I'm not a politician, fortunately, so I'm saying how I see the position. And I think, again, history is helpful here, which will be my closing point, really, is that Labour traditionally were constitutionally quite conservative, saw the system as being a thing which could work for them. They will get their turn in power. They'll come into power. They can use parliamentary sovereignty in a centralised system to deliver things like the NHS. Well, thankfully, they did deliver the NHS. I'm very grateful for that. We're seeing the benefits of the NHS now. However, there are certain drawbacks to that approach. And I think Labour then it's clear that Labour got more interested in constitutional reform when they were closed out of power for a long period of time, from 1979 to 1997. At the beginning of the 1979 period, it looked like the Conservative Party were more likely to introduce a genuine Bill of Rights or even a written constitution. Lord Hailsham, people like this saw it as a potential protective mechanism against the populist Labour Party that came to power under the first past the post system. Well, all of that's really been reversed. Labour got a lot more interested in constitutional reform, introduced things like the Human Rights Act, which took us closer to having a codified constitution than we were before, and introduced some of those reforms. Now, I fear that Labour may be passing through a period of opposition that is going to be even longer than the 1979-1997 period. If Labour, as I fear they will, loses the next general election, then it will look quite likely, depending on timings, that they're definitely going to be in opposition for at least as long as that, and possibly longer by that point. So I think hopefully one positive of that is that Labour will become more interested in constitutional reform as they did during that previous period, because the system doesn't look as attractive to them, and they may start to look at a codified constitution as a genuinely protective mechanism against some of these threats. None of that's easy to achieve for the reasons that have been outlined before. And I think probably coupled with that, which doesn't necessarily need to go into the written constitution, would be a move to some kind of proportional representation system, which was obviously looked at, but for reasons I don't need to go into, wasn't actually implemented, but certainly as a pledge to a referendum in 97. So that's where I see potentially Labour moving on this issue and why I think it might be necessary. But that's not to underestimate any of the difficulties that we've talked about. And I certainly wouldn't want to see a written constitution being introduced right now in the current climate and with the current particular group of people who are in power. Thank you.
Thank you very much. That was fascinating. So I'm just going to have a look at the questions. So there's one question here about the Conservatives and their closeness to the monarchy. I think the question in there is the other Conservatives' views towards the Crown going to create a less conducive environment to introduction of a codified constitution? I'm heavily editing that question to get something out of it, but I suppose I'll open up to everybody else, but I suppose my answer to that would be, well, the Conservatives are sort of by nature conservative and probably won't do anything to undermine the Crown or anything that keeps them in power. But I'll open up to the panel. Meg?
I don't have a strong view on this, and I'm not sure to what extent it's a factor, really. I mean, obviously there are constitutional monarchies with written constitutions, and we're not one of those. But being a monarchy doesn't stand in your way of having a written constitution, and the monarchy doesn't. I mean, there have been moments. I'm perhaps the only person on the panel to have mentioned the word monarchy, but only in as much as it has been drawn into controversy in the Brexit years, not in the sense of whether we should keep it or get rid of it, but with respect to what its powers are. I mean, there were not only through the prorogation, but the suggestions at an earlier stage that royal assent could be denied to bills which had properly passed through both the House of Commons and the House of Lords. So this tumultuous period has actually brought the role of the monarchy into question and controversy in a way that it really hasn't been, I don't think, in my lifetime in those kind of ways. But the truth is that the monarchy exercises very little discretion. And when you talk about the Crown, I mean, this government and to an extent the May government have been great defenders of the Crown in Parliament, which principally means the political executive. And that's a very different thing.
I suppose taking on from that, do you think then, although the things like Queen's consent, which has come somewhat more into the public eye recently, or at least those who look out for it anyway, have it's been a bit more in the press. To the extent that that's compatible with a modern democracy, I mean, I can't think of another sort of mature democracy where an unelected head of state has so much say, or at least input over the passage of legislation that affects them particularly. I don't know if we want to address that question.
Maybe I could thank you for giving me an opportunity to plug a Constitution Unit report, because there aren't many people who can claim to have a report which covers extensively the question of Queen's consent. But we published one last year by Paul Evans, a retired House of Commons clerk who loves a bad pun. So it's called Breaking the Law ? With the braking spelt like the brakes of a car, which asks about the role that the executive ought to play in the opportunity to veto legislation in different ways. I mean, look, this I think is one of the little untidy anomalies in our constitution. It could probably do with tidying up, but compared to the enormity of some of the things that we're talking about here, the potential breakup of the union, the global rise of populism and anti-politics and decline of constitutionalism, it's pretty trivial stuff, I would suggest.
Yeah, and if I can just come in there, I agree. I think that it's a thing which which crops up in the Guardian. And I don't mean that to demean the Guardian, but it's a kind of a staple that comes up every few years. I don't think it's of enormous significance. That's not to say I'm personally a massive supporter of monarchies or the need to have them, but I think that you can have a written constitution with a monarchy or without. And after all, the Queen is head of state of countries with written constitutions, as well as being the head of state of the United Kingdom, such as Australia, Canada. There's no reason it can't happen. But I think it is interesting that although obviously the Conservatives are never ever going to say they're anything other than the party of monarchy. Mind you, I don't think Labour, let's put the Corbyn leadership to one side, but generally I think Labour are very unlikely to take an overtly anti-monarchy policy. I think that the behaviour of the government, as Meg alluded to, but the behaviour of the government during the prorogation issue did undermine the monarchy. And I think, they are, some kind of constraints. And I think the prorogation power is something that could perhaps go in a codified or written constitution, and that would actually protect the monarchy. Because if you've got clearer basis on which prorogation takes place, then you're insulating the monarch from having the powers they exercise being brought into disrepute, and putting the monarch in a very, very difficult position where they've got a choice between doing something which is constitutionally problematic, turns out to be illegal, or refusing the advice from a prime minister or senior ministers, which are very, very difficult position to put a monarch in. And obviously they're probably, except in the most extreme cases, are going to go with the advice of the prime minister. But we're going to see a reversion probably to the old way of dissolving parliament as well, which is quite interesting on that note. And that's a problem. And I think, maybe a codified constitution could help with that and actually protect the monarchy if that's something you want to do.
Sionaidh?
Yeah, I totally agree with what's been said so far. I think there are a couple of interesting historical points one could bring up here. And they may be of relevance to the issue of potential independence of nations of the UK today. When Ireland became the Irish Free State in 1921, 1922, it became a dominion, and for the first time was required to actually swear allegiance to the crown. And for Scotland, this actually could be an issue, because in the 2014 independence referendum, the idea was to retain the monarchy. And if an independent Scotland were to retain the monarchy, then there would be this issue of exactly what relationship it had to the crown and the whole question of swearing allegiance to it. This hasn't been an issue for a long, long time. Quite rightly said, Australia, Canada, they are monarchies. But one other difference is that while royal assent hasn't been exercised in the UK since Queen Anne's time, it was exercised when it came to former colonies. Their governor generals, they could veto all sorts of things in the past. So there are interesting past instances of the role that the monarchy had that we perhaps shouldn't forget so easily, because history can tell us some lessons and can inform where we're going in the future.
Thank you very much. I've had a question from Stephen Hockman, and I will just read this one out. Would the panel agree that the present government's approach to the Constitution is likely to lead to the breakup of the UK and the secession of Scotland and of Northern Ireland, an outcome of which would or should lead to the government to fall? But do you all agree that the opposition should nonetheless press for rapid cross-party constitutional change, which might deflect such a breakup of the UK? Who would like to take that one first? Sionaidh?
Well, I suppose there are 2 points to that question. One is about whether there would be a breakup of the UK. I think we have to wait a couple of months to see what's happening in Scotland. I mean, there was a very interesting talk given earlier today by Kieran Martin at the Blavatnik School in Oxford about the whole question of a Scottish independence referendum. And he made what I thought was a really interesting point, that if an independence referendum, if a Section 30 order giving Scotland the power to hold a referendum is denied, then you are removing any constitutional means for independence. And then where do you go from there? Because then there's a question, well, would there be violence? Scotland doesn't have a tradition of violence, but we've seen where violence goes in Catalonia or in Ireland between 1916 and 1921. So I think that this is unsettled business. It's not clear yet what's going to happen. But yes, I mean, if there is a breakup of the UK, that is a huge constitutional change. History has told us that all sorts of things can happen. You know, Brexit happened, a COVID crisis happened, and sometimes, you know, life goes on, sometimes it doesn't. I don't feel particularly well equipped to answer the second part of that question about what should happen in that event. I'll leave it to others to answer that.
I could come in if that, or did, okay, yeah. Well, I think well, again, there's an interesting theme here is that we have a government that purports to believe in things like the constitutional monarchy, like the union, or like parliamentary sovereignty, until they get in the way of something it wants to do, and then they can be kind of discarded quite lightly, or at least, you know, manipulated. And certainly, I think that the current behaviour of the government is reckless regarding the future of the union. If one accepts the future of the union is a good thing, which, you know, I'm happy to say I'm neutral on, but if for those who believe in it, as the Conservative and Unionist Party presumably would say they do, there seems to be a degree of indifference. But I think on the question of whether the government would fall in the event of, say, Scotland, if they had a referendum, if they voted to leave, well, in some ways, from the point of view of the Conservative Party, they're in a stronger position. Then it's much easier for them to win a general election if Scotland's not part of the UK any longer. So maybe that the calculation is they're not that bothered. But certainly, I think at that point, Labour would need to be pressing for some kind of serious constitutional convention. To definitely, I'd agree with that. To look at the system, although at that point it's almost too late. It may already be too late for some of these, for actually anything. I don't want to sound defeatist, but it may already be too late for Labour Party to do it, or anyone to do anything to stop some of these forces that work. I think we're looking back at the debates, and we heard a bit about this, the debates of what became the European Union, open brackets, referendum, close brackets, Act 2015, going through Parliament. For the reasons which Meg has said, that there was an assumption it would probably go a certain way, which it didn't. The failure to really scrutinise what was going on, particularly by Labour. And if you look at who opened for the government on that, it was Philip Hammond saying this is all going to be wonderful, it's going to solve all the things. And if you look at who opened for Labour on that, it was Hilary Benn. Both of them, considering the positions they later came to be associated with, were completely blithe about the whole thing, really. And the fact that Labour voted for that legislation, even though it wasn't in their referendum. The Liberal Democrats voted for that legislation, even though it wasn't in their manifesto. So I think it's much too late, I fear, for that setting change something that it may be too late to do anything about, I suspect. But where it will end up, I don't know.
Well, I think that illustrates something, which is that it's very difficult for politicians to deny referendums when there's a demand for them. David Cameron granted one, obviously, and then he granted another one because he thought he'd double his money or something, and it didn't work out very well for him. There are some really huge questions here, aren't there? And Sionaidh already plugged another seminar, and Sionaidh has also already mentioned the name of this person whose seminar I would plug, that yesterday there was a really fantastic event hosted by the Centre for Constitutional Change in Edinburgh with Michael Keating, talking about his new book about the State of the Union, and really, you know, just deep and searing analysis. And in terms of what how the government is handling things, I mean, Brexit is a big part of this, clearly, as I think we've all said. But in terms of what's happening now, you know, one of Michael Keating's sort of side remarks was that you're not really going to enamour people in Scotland to the union by going and hanging Union Jacks everywhere. That's it's a lot more complicated than that, and yet that's the current response. But one thing I think that's really, really important, and I go back to the point about referendums and the Independent Commission on Referendums, that we're potentially looking at a referendum in Scotland, and we're potentially looking at a referendum or two referendums on the island of Ireland in the north and the south on reunification at some point in the foreseeable future. It is really, really important that we don't rerun the Brexit referendum, in as much as putting a question in front of people that is a very complex question, with uncertainty about what a vote for change would mean. And I mean, that could be seen as a convenient recipe for delay on the part of the government. But I think it's really important that there is a blueprint for change put in front of people in either of these two areas if they're going to have a vote, because otherwise you end up back in the Brexit situation where would it cause the fall of the government? That's not something I'd really thought about. I guess Boris Johnson might choose to walk away after a failure in a Scottish independence referendum, the same way that David Cameron chose to walk away. But it certainly leaves a difficult question for somebody as to what on earth this means and how we navigate it. And it would be very, very difficult, even in the case of Scotland. And clearly in the case of Northern Ireland, the implications are even more serious. To plug another piece of Constitution Unit work, currently my colleague Alan Rennett, the Deputy Director of the unit, is leading this working group on unification referendums on the island of Ireland, which is looking really carefully. It's already issued an interim report, and the final report will be coming soon, in really thinking through the implications of how and when and under what circumstances to hold a referendum, not advocating for one or against one or for one particular solution, but asking really important questions about the dynamics. And we mustn't walk in blindsided to future referendums that have huge consequences, because we've seen just how destabilizing that can be.
Thank you very much for that. I suppose one follow-on question I had was, I mean, Meg, you spoke earlier about how we're not in a place politically where we could possibly sit down and write a constitution where we'd all agree, but would not the process of holding a convention to look at the constitution operate to bring people together to find that consensus, or not?
A particular bugbear of mine is that consensus is a much overused word in British politics. We used to call it majority. Consensus is virtually impossible to achieve, although you want to get as close to it as you can on big questions of constitutional change, obviously. Look, I think that just to try and be a bit more positive, we've all agreed that Brexit was a huge constitutional, I hesitate to say moment, because as I've said, that tends to have a particular meaning, but it's been a huge constitutional shock, and it has very major constitutional consequences. And sitting down and talking about what we want from our constitution has to be a good thing. But I think that we've also all agreed that the likelihood of because a constitution, I mean, Andrew is quite right to pick us up on both the language and on the nature of that constitution. Some are much longer and more detailed than others, but it has to have some content. If you write something down, there has to be something in it, which means that we have to have agreement on those institutional arrangements. And at the moment, there is agreement on virtually nothing. So I think it's moving to a process of deliberation about what we want from our constitutional arrangements, what we want from our politics, what we want from our political culture, the extent. I think the key question, I mean, at the UK level, is the extent to which we want constraints on the political executive, the extent to which we think it's okay or advisable for judges to have some control over some of these big decisions, for example. I think that these arguments have got extremely polarized over Brexit. So when after the prorogation case, public opinion polls showed that people who supported Brexit were overwhelmingly against the Supreme Court having a role, whereas those who opposed Brexit were overwhelmingly in favor. We can't afford to have those kind of polarized views of our institutions. We need to bring people back together and agree some of the sort of core principles about checks and balances in the Constitution. I think we should do all that, and we should have a conversation, but I think that trying to push people into an agreement at this time could actually potentially do more harm than good, because it could become very divisive.
Anybody else to comment on that point?
I think, I mean, obviously a thing which gets talked about a lot, and which I know Constitution Unit have done work on, I've done work on a Roundtree project on, is the idea of some kind of citizens' assembly. Now, again, I think you've got to be very careful that we don't oversell these kind of things, but potentially there are mechanisms there where you get a, you know, a random selection of members of the public, or however you want to recruit it, to look at some of these issues. Because I think, coming back to Meg's point again about what do the public think about these things, partly depends the way in which the question's framed. If you ask people, should Parliament be limited by, should the executive be limited by Parliament? Should the executive be required to have votes in Parliament before major decisions such as going to war? They'll say yes. But if you say, should the executive have the flexibility to respond in a way that protects our security and not be hampered by procedures, they'll say yes to that as well. So I think, you know, it's difficult the way in which the question's framed, and I presume this written codified constitution, I keep slipping and saying written, but this constitution we're talking about would have to be ratified in some way. I dread to think of it being ratified by a referendum, and what that campaign would look like, and what, say, the Daily Mail would have to say about a codified constitution and what was in it during that campaign. But it's going to have to be ratified in some way. So you're going to need to, maybe by super majorities, whatever. There are different ways of doing it. I wouldn't support a referendum, but I know many would assume that was necessary. But you're going to have to involve the public in some way. But there are mechanisms whereby you can do that. And in theory, at least, you can take some of the kind of partisan struggle out of it by giving it to a group of people, as they've, you know, given people such as in the Republic of Ireland that we talked about earlier, have had a constitutional convention where they've managed to help resolve some very, very tricky issues. So there are options there that I think are definitely worth looking at. Again, we've got to look at the overall process, what we're going into here. How doable is it? Is it better to start small and build your way up before you go for a full discussion of a code of a constitution? But definitely, I'd say there are things there that should be looked at in terms of citizens' assemblies. And there's a lot of good practice around the world that we can now draw on, and, you know, work being done in this area by the initiative I'm involved with, the Citizens' Convention on UK Democracy. So there are things to be looked at there.
Maybe I could just throw in, I didn't do this at the start of the previous question because I felt like I'd already done too much of it, but it would be remiss of me not to mention that the Constitution Unit does have a new project which is going to hold a citizens' assembly on some of these core questions at the heart of the Constitution. It's paid for by the Economic and Social Research Council, and that will also do some large-scale sophisticated polling, using polling experiments to try and get people away from their sort of entrenched views. You know, I like Boris Johnson, therefore I don't want the judiciary interfering. You know, you've got to take them away from that and say, well, you know, the Prime Minister could be Jeremy Corbyn. What do you think about the judiciary interfering now? Because I think on some of these really core questions about how we achieve constitutional checks of the most basic kind, we need to ask the public what they think. I think the public, when these deliberative exercises are almost the opposite of referendums. You know, referendums try to make things simple and give people just a yes or no. Deliberation does the very opposite. It encourages people to think things through from every angle. Referendums tend to polarize, and deliberative exercises actually tend to make people much more respectful of each other's points of view, and they become much more prepared to compromise and to reach agreement, and they actually become more appreciative of the work that politicians could do, because actually that's what politics is all about. And I think what we need is exercises that bring people together, and maybe to inform politicians of considered public views on some of these most fundamental questions about constitutionality, democracy, and the way we want to do our politics.
Sionaidh. Oh, you're on mute there.
One probably has to divide our, can you hear me? Oh, no. Yeah, am I unmuted now? Yeah. divide off the devolution issues maybe from other issues, because I think they are so pressing now, particularly in the case of Scotland. But I'm not sure people in other parts of the UK are really that concerned about them. And I think also there are 3 unions than just 1 union. So the situation is different for Wales, Northern Ireland, and Scotland. And I think there's a certain amount of resentment that somehow devolution is seen as framing an agenda. It's the old Dyson question that it could lead to a federal UK, and a federal UK requires a written constitution and a total shake-up that people in England don't want. Now, I don't happen to agree with that, but I think it is possible to improve the situation with devolution without going for a whole-scale written constitution. And by framing the issue in such a way as to suggest that you can only solve the Scottish problem or the Irish problem by a written constitution, just presents some sort of insurmountable hurdle, because a lot of people in England say, well, we don't want any English devolution, we don't want any of this or that. And so I think you could keep the issues separate, and find that improving, ameliorating the devolution situation needn't necessarily involve a written constitution.
Thank you very much. And I believe there's a project, or has been a project going on in the House of Lords about a new Act of Union, which I think seeks to do that. I've not had the opportunity to read it, but I don't know if you have any views on that, Sionaidh.
The bill was introduced to the House of Lords a couple of years ago, I think, yes. And but I'm not sure it was actually federalism as such, because I do think it sought to retain parliamentary sovereignty overall. I mean, I think one could also question that whole issue of parliamentary sovereignty and how big an obstacle it is to finding solutions to constitutional problems Britain may have. An awful lot of people are wedded to the idea that parliamentary sovereignty is just an obstacle to many, many things that could be found. And they're asserting it as a fact, when maybe what is the fact is the strength and the might of one particular nation and 85% of the population wanting to do things a certain way. But I think parliamentary sovereignty has become an awful lot more nuanced than a rather bleak absolutist vision. And so I think there's more scope for constitutional experimentation there, advancement.
Maybe I could just jump in there and slightly correct something that Sionaidh said, but connect it up to something that Andrew was talking about before. Andrew talked about the electoral system, and I'm not necessarily a proponent for electoral system change, but you can never say that 85% of the population want a thing. The elected representatives of 85% of the population may want a thing. And actually, one of the things that the first past the post system has done is polarize the nations politically. Because of course,
so all I meant to say was that England is about 85%.
No, I know. I'm just using it as an opportunity to say that there's a connection between these things, because clearly the SNP overwhelmingly represents Scotland at Westminster on not overwhelmingly more than 50% of the vote. I'm not sure they even reached 50% of the vote. And the Conservatives are much stronger in England than they might look under a proportional system. So, the electoral system divides. That makes the nation feel more divided than it really is. There are quite a lot of Conservative voters in Scotland, as Sionaidh knows, and there are a lot of other voters in England, and the government doesn't necessarily.
Yeah, Scotland was Conservative dominated in the 1950s. So.
Yeah.
Great. I'm just mindful of the time. I mean, if you wouldn't mind going till 8, we have maybe time for one more question. That's all right with everybody. So it leads on neatly. I've got one question here from Kevin Hind, and it asks, effectively, sort of leading on from that, does parliamentary sovereignty get in the way of meaningful human rights, in that if we can repeal it tomorrow, then are they really secure? And I suppose that goes for any fundamental reform or things that we hold dear in our constitution. is that if we can repeal it tomorrow, then what's their value, and is parliamentary sovereignty not then incompatible with a modern democratic state? Andrew?
Okay, thanks. I mean, I think there are enormous problems with the doctrine of parliamentary sovereignty, and some of them other speakers have commented. That how intellectually coherent is it in the first place? Which version of it do you want to follow? Do you want the Dicey version? Do you want the Goldsworthy version? Do you want? There's many, like Hines. There are many different varieties on offer, and they're not all compatible with each other. And then you get onto the issue of, so even before you get to whether you think it's a good thing or not, what is it we're actually talking about? I mean, again, we've heard talk about Dicey. Dicey Times didn't seem to be that bothered about parliamentary sovereignty when Home Rule was introduced for Ireland. He seemed to think it would be okay for people just to not obey the law. So he didn't necessarily, when it led to something he didn't like happening, he didn't necessarily think you had to really follow it. Also, I mean, let's not forget that Dicey was the most important early, not the only, but the most important early advocate of the use of referendums, which are quite difficult in some ways to reconcile with parliamentary sovereignty. If you look at the article he wrote in, I think, 1890, ought the referendum to be introduced to England, by the way. He used the term England, which everybody always seemed to use in the 19th century. Badger, Dicey, you name it, they always talked about England. But let's put that to one side for a moment. Ought the referendum to be introduced to England? He seems to argue that really we should get a codified constitution like other countries in the world, but that's probably not going to happen. So in the meantime, let's use referendums as a way of protecting us against the tyranny of the majority through parliament. And this is Dicey arguing this. So if he doesn't really want to take the whole thing too seriously, I don't feel that I'm particularly obliged to either. However, a lot of people do believe in it or claim to believe in it, as I said earlier, until it gets in their way. And the big proponents of parliamentary sovereignty who took us out of the European Union didn't like the idea that the approval of Parliament through a statute had to be secure before you could activate Article 50 of the Treaty on European Union. And the Supreme Court, the supposed enemy of parliamentary sovereignty, had to actually uphold parliamentary sovereignty twice in both Miller cases. So these are all very complicated issues, and it seems that parliamentary sovereignty is convenient at times, but not at other times. But it shouldn't be allowed to get in the way of us doing, if we want to do something. There was a time when constitutional purists would have claimed that a large proportion of the land surface of the earth was subject to the sovereignty of what was called the imperial parliament not so long ago, and that parliament could make law anywhere in the world. Well, some people argue it could change law of France if it wanted to, which now people don't really accept any of that any longer, and most of the countries that were once part of the empire have gone and aren't subject to parliamentary sovereignty. It is possible to get rid of it, and the way things are going, perhaps Scotland won't be subject to parliamentary sovereignty much longer, and Scotland will get a written constitution if they leave the UK. I'm not taking a position on what they should do, but that will happen. So I don't think we should be too overawed by this doctrine of parliamentary sovereignty, and certainly we should take into account that those who purport to be its strongest advocates were quite happy to put it to one side when they got a referendum result that they wanted.
I remember being told once that parliamentary sovereignty never applied to Scotland, but
there's that too, yeah.
Lord Cooper's view.
Yeah, can I just cut in here, and I'd like to give the final word to Sionaidh, because I think she's going to say something probably devastating on this, which I will completely agree with. But this term is bandied around a lot, and it's bandied around, as Andrew has referred to, in somewhat contradictory ways. It's parliamentary sovereignty with respect to whom? With respect to the EU, with respect to the judges, with respect to the devolved institutions. The parliamentary sovereignty that I'm interested in, and it's maybe not quite the right term for it, but is with respect to the executive. And I think, or with respect to the people in referendums is another option. But it's used in terms of who should be on top in our system. Should the judges be on top, or should the politicians be on top? The one thing that I'm clear on is that Parliament should be on top, and officially is on top, of the executive. The executive answers to the legislature and not the other way around. And in these arguments, even over Brexit, even the sense of what we mean by parliament in these arguments seem to get confused, as I referred to with respect to the Crown in Parliament, that it was used as a reason for the executive to assert itself. But I think all of these arguments are very kind of adversarial and rather unhelpful. And I think that what Sionaidh advocates, and I hope she will, she referred to it before, is not a sense of sort of who's up and who's down, but a need for balance in the Constitution, which might be a more sort of productive way of looking at things.
Yes, I totally agree. I totally agree with what both Andrew and Meg have said so far. I think that the doctrine of parliamentary sovereignty is intellectually incoherent. One can pick all sorts of holes in it. And I think looking back 100 years or more, actually, it was not particularly coherent. Dicey might have claimed that the imperial parliament could legislate for the British Empire all over the world. But if you looked at the reality of the British Empire, it was a complete hodgepodge, and there were all sorts of territories, things like protectorates where sovereignty was very clearly shared. So it's always been more of a myth than a reality. But then you come back to this factor that I think underlied a lot of the British Empire, and it underlies what's going on now, which is power. We can do this because we are big and we are strong. And power without any sort of normative justification is a very, very uncomfortable place to be. But you do come up against it. And it's basically, I think, what's happening after Brexit, that the UK government is embracing this, what Michael Kenny has called hyper-unionism, which is the whole idea of a unified state, and the idea that the British Constitution is unified. And that just doesn't suit what's developed over the past, not just 20 years, but more than that. It just wants to ignore all of that. And there might have been a certain amount of accommodation, cooperation, things might have worked relatively well in the past when nobody raised these questions too much. But now there is this sort of bifurcation, this adversarial approach, and it's a very, very bad thing. And it may lead to worse things. But I don't think we should justify it in the name of some sort of unified, coherent doctrine called parliamentary sovereignty, because that there is not.
Thank you very much. Just looking at the time, and I've just had a text message from my girlfriend saying dinner is ready, and if I don't come through, it will be thrown away. So thank you very much all for coming along and watching, and thank you very much for our panelists, Dr. Andrew Blick, Professor Meg Russell, and Professor Sionaidh Douglas-Scott. I hope you've all enjoyed it, and I am told this is going to be this is being recorded and will be available on YouTube and elsewhere. So thank you very much to everybody for taking part, and good night.